today, we're really excited to have Professor Yanmei Lin, Professor of Law from Vermont Law and Graduate School, here to talk about civil society's place in China's environmental rule of law, and particularly focusing on the role NGOs have played and how they're adapting and continuing to play a role in China's development and enforcement of environmental governance. Professor Lin is certainly an expert on this, not just as a scholar, but also as a practitioner. Currently, she serves as the acting director of the Maverick Lloyd School for Environment at Vermont Law and Graduate School, in addition to serving as a law professor there. And she also serves as the deputy director of the U.S.-Asia Partnerships for Environmental Law. So as you can see, she wears several different hats here in the United States in academia. But prior to that, she worked in the environmental sector for many years in China, including developing and implementing the Partnership for Environmental Justice project, which supported the establishment of one of the leading law clinics focused on the environment, but more importantly also biodiversity in Yunnan province, and also led to the provision of legal aid services to NGOs and also to indigenous and vulnerable communities in those areas. And she also worked during her time as a practitioner in China to help design, implement environmental law training programs for Chinese judges as well as for Chinese lawyers. She has also served as a program officer for the American Bar Association Rule of Law Initiative China program, and before joining Vermont Law, she was a researcher for the China Institute of Environment Resource Protections in Minority Areas at the Central University for Nationalities. So we're delighted to have her here to speak on this topic, and we're also equally delighted to welcome today's discussant, an expert in rule of law China himself, Professor William Alford, who has written extensively on many aspects of China's legal reforms, including its development of environmental laws. Professor Alford is not a stranger to most of you in this audience, but for those of you who don't know him, he is the Jerome A. and Joan L. Cohen Professor of East Asian Legal Studies at Harvard Law School, where he also is the director of the East Asian Legal Studies program, as well as the chair of the Harvard Law School Project on Disability. So please join me in welcoming Professor Lin and Professor Alford.
Thank you so much, Professor Wu and Professor Alford. And I'm so great honored to be here, have this opportunity to share my research and my interaction with the civil society, organization, and environmental rule of law in China. So this photo is captured in December 2017. So two group of environmental civil society organizations, we acronym CSOs, not NGOs, Friends of Nature and Wild China, they undertook a week-long rafting trip to the Shiyangjiang River, the Gaza River, and the middle of the Honghe River Basin to undertake a biodiversity survey. And they found there's a team of biologists, legal experts, attorneys, NGO, CSOs, activists. They found undocumented endangered green peafowl with tracks and remnant monsoon forests. And they're trying to gather evidence critical to what become China's first preventive environmental public interest litigation. Because you see from the photo that there was a planned dam that is almost finished. Actually, they've done a lot of things. The only thing they need to is to close the area, submerge the habitats that the team of experts, biodiversity, ecologists, researcher and environmental NGO found that is a critical habitat for the endangered green peafowl. So the story actually very dear to my heart. So you can see I wear the green peacock t-shirt for this talk because encapsulate the theme of my talk today. So civil society organization in China, as you always know, is operating under constraints. Nonetheless, they're finding creative ways to protect the environment and safeguard the public interest. This is a team of the experts underneath, and this is the team of the NGO plaintiffs and their attorneys. So when I saw the experts, and also in the middle of this, world-famous photographer for endangered species, and he testified to protect the habitat for green peacock, my tears is in my eyes. So what roles do China's environmental CSO play? I use the metaphor, you can see in my title, fire alarm, to describe this fire alarm alerts both society and the state environmental dangers. But they exist within the iron hand of centralized authority and bureaucratic discipline. So this talk trying to ask the critical question, can China's environmental civil society organization still make a difference when the state both authorize but constrain its voice, in particular in today's era of very tight control? So to answer this question, I turn to Professor Zhou Xueguang's theories. He recently published a book on the logic of governance in China. It's Cambridge in 2022. His theories really provide a crucial lens for me to understand the limits and possibility for CSOs. So he described the mode of governance in China explicitly. This is the fundamental tensions on the left, on the box. The fundamental tension is centralized authority and the effectiveness of local governance. And as you know, China have at least 5 levels of governments, from central, provincial, prefectural, county and township government. And all this fragmented hierarchies create response mechanism. On the one hand, the central authority want the policy uniformity and also can be intervened arbitrarily at any time in any sector. But on the one hand, on the other side, the local, in order to effectively address the problem, they need to have flexibilities. And that leads to what Professor Zhou mentioned, unanticipated consequence. The key one is political cycles. That's why I always using tight, loose. So this is kind of a swing or preference than tight control or tight coupling or loose coupling. And because this characteristic of this governance mode, and also limits to rule of law, our profession, and also limit to rationalization of bureaucracy and limited to professionalism, like scientists and attorneys and etc. But he mentioned at the end of his book, he said there is a strong continuity of China's mode of governance, but there are 3 aspects he provides can be changed. The first aspect is the rhythm of shutting down and opening up. The second rhythm is the changes of the organization capacities. And right now, it's tight coupling, but also upward with concentration. This is a kind of background of the case. And then also the value and ideology. And the ideology legitimization, which is the legitimacy in its analytical framework, is not strongly rooted in law and rationalization, but in fealty to central ideology vision. And ecological civilization, like environmental protection, green environment, is part of the 1-5 vision that the party-state system now envision. So the phrase 绿水青山就是金山银山, green waters and green mountains are gold, and civil mountains reframes environmental protection as both economic and moral imperative, and aligning the state goals and the party legitimacy with sustainabilities. So with this analytical framework, a lens to look in the role of CSO, let's look at how it rise. Like the CSO are focusing on are mostly grassroots NGO, not affiliated with like government, like we call it government organized NGOs or CSOs. So the 2 decades from 1993 to 2014, I call it the rise of environmental civil society and the free environmental access rights. So everybody think the opening moments in 1979 when I was born, but actually the turning point, one of the key turning point is 1992. Domestically, you can see the 1992, Deng Xiaoping, the Commander Deng Xiaoping in his Southern Investigation 2 to Shenzhen. Shenzhen and Pudong is at the time are very remote local areas. And this is the symbol that the top leaders call on local innovation, basically, and aboard premium Li Peng's attended, actually in the middle is Li Peng, attended the Earth Summit and Brazil, Rio, and signed the Rio Declaration and the United Nations Framework of Convention Climate Change and Convention on Biological Diversity, and also the Agenda 21st, which is enshrined the Principle 10 of public participation. So this is the context for the rise of environmental civil society. So on June 5, 1993, the World Environmental Day marked the founding of Friends of Nature, one of China's oldest grassroots NGO. The leader is Mr. Liang Chongjie. And now it grows to a national membership type of network. And its success and its early campaign on protecting the Tibetan antelope anti-poaching, and it also encouraged a lot of other peers, grassroots NGO established, including Fujian Green Home, Green Village, Green Earth, Green River. They even formed an alliance to have fight a public campaign against the new river mega dams. And nowadays, just give a little bit data in a survey conducted by Ming Shan Dao, and they collect the data. Nowadays, there are more than 5,000 environmental CSO across China. Even though a lot of them, the size are very, very small. And environmental legislations, like at the same time, the environmental legislation has proliferate because, as you know, China entered into WTO in 2000, the rapid urban development, industrialization, and become the world factory. So the pollution crisis, speed losses, and citizen protests in PX project and incinerators, it really challenged the regime's legitimacy. So at the time, legislation has moved. Actually, Professor Effer's 2001 publication talk about how National People's Congress and at the time the National Environmental Protection Forum Alliance have a sectoral battle to try to use more stringent and innovative legal tools in China's air pollution prevention law. So China have actually evolved environmental legislation over the years and every updated. And the institution reform make the environmental administration agency, starting from just a small office under the Ministry of Construction and Urban Development, become now the Ministry of Ecology and Environment. Their office building moved from the second ring, Chegongzhuang, to really close to Zhongnanhai in Chang'an Street. And the most remarkable establishment is the new chapter on information disclosure and public participation in China's new environmental protection law that was adopted in 2014, almost the end of the loose decoupling era. But we catch the opportunity, so this law enshrines free access rights. One is access to information that is make the enterprise need to disclose their pollution informations. And in this forum, we have Mr. Ma Junxie, the Institute of Public Affairs and Environment's work, how they using transparency, developed the blue map, helping the green choices hold the supply chains of big brands to accountable for their environmental performance. The second right on access to access to decision making, which is first enshrined in the environmental impact assessment law, and later regulation, and now actually recognized by the new environmental protection law. And nowadays, in the EIA approval and planning process, actually CSOs and public have many entry points to submit their comments to the authority to request adjust the design of the development projects. The most remarkable change is access to justice. It first started in 2012 when the amendment to civil procedure law created a public interest litigation system under the civil litigation system. And it is not until the environmental protection law that finally clarified who can represent the social public interest. And in this law, it's the first time to recognize or accredited CSO that was established, that is established for 5 years and at the county level that can have legal standing to sue polluters and ecological destructors. By 2020, the CSO had brought over 400 cases, and last year, they still brought 240 cases. And a lot of cases are landmark cases, and I'm going to share 2 cases in this time. One thing I also want to slightly mention, a little bit sidetrack, but it is important because without the judges, even you have brought the case, but if they don't understand environmental science, environmental cases, you won't win in the court or get the results that you need. In June 2014, Supreme People's Court decided to create a specialized environmental division or tribunals within the SPC. And since then, actually the experiment, the pilot started in 2007, but it's not until 2014 the Supreme People's Court have its own division. And this picture just shows the intermediate court level, but according to the statistics show last year's environmental and natural resource adjudication white papers, it has more than 2,000 specialized environmental courts and tribunals and benches now established in China. And this is the picture that Vermont Law School has designed and collaborate with Klein Earth and also Asian Development Bank to deliver trainings for the Supreme People's Court judges. Judge Zheng Xuelin is at the time the Chief Justice for the specialized environmental bench. Okay, so more exciting, I want to share 2 cases and how they actually, in concrete case, in this tight control era, because I just mentioned the 2014, when they got the legal standing, immediately almost in the era of Recentralization. And this first case I want to share is already shown in my prelogue. This case is first actually identified by a master student conducting his field work on peacock or peafowl. It's an endangered species and listed on the IUCN Red List as endangered. And this student found, wow, this is a particular area's habitat for green peacock, but it's going to soon be submerged by these hydropower stations. And he sent a message to Wild China, which is a famous photographer, and he also captured the image of the peafowl and shared with the network of CSO, including Friends of Nature. So that's how they organized the biodiversity survey trip down to the deep river valleys of the Honghe Basin. And once they found the evidence, they actually haven't started the suit immediately. They actually sent letter to MEE, the Ministry of Ecology and Environment, because it is MEE approved the project EIA report back in 2014. And they hope, based on the concrete evidence, this is the critical habitat, you have to stop this dam. So they hope MEE will overturn that decision. After several rounds of negotiation and seminars, MEE is still hesitant to overturn the decision. So in the end of 2017, they decided to bring this case to the court. And as you know, CSO hasn't been authorized to sue against the government, so they cannot bring MEE to the court. So the defendant is the Xinping Hydropower Cooperation Kunming and the Design Institute. So the developer and the EIA, which third party consultants. And as I mentioned, I'm so amazed by the trial because there are so many procedural hurdles to dismiss the case. But in the end, the Kunming Environmental Court take up the case, and then it's not until the August 2018 we have a trial. At the trial, although the defendant agreed with everything they find, but they said, everything we do is legal. We got all the permits, all the approvals. So I at the time, I'm actually very pessimistic. How a division-level intermediate court can de facto challenge a ministerial-level MEE's decision, even though they are ruled against a state-owned company, well, at least an enterprise, a private party in China's sense. But surprisingly, actually, the ruling you can see in March 2020, Kunming Intermediate Court actually ruled in favor of the plaintiff, even though it doesn't support exactly the claim that the NGO want to terminate the project, ultimately stop, but they actually suspended the project, require supplemental EIA. So that's very smart of the judges because they didn't overturn the MEE's approval, but they actually suspended the project. And the provincial government put the areas into the ecological red line. So de facto, the developer will not be able to finish its project. So finally, they abandoned the project. So the question is, why did judicial assertiveness occur amid this tight control? So you can see the picture down here. The COP15 of CBD, Convention on Biological Diversity, will be held in Kunming at the end of the year 2020. So the Green Peafowl become the symbol, actually part of the logos of the CBD COP conference. So I think the opening up and engage with the international community change the dynamic of this case. And this case actually aligned with the central policy, especially with this international event. The second case, the CSO challenged even bigger, even powerful actors. They filed a case against the state grid. And as you know, China only have two utility companies, very different from the US, the state grid and the northern grid. What's the problem here? The problem here is CSOs and also renewable energy operators, they found, even though China have rapid development of the renewable energy power, but the state grid is very slowly to absorb those energy. So this case called renewable energy curtailment case, because in 2014, 2015, 2016, there are more than 40% of the renewable energy generated by solar farm and wind farm was not be able to put into use as electricity for households and factories because they are unable to get into the grid. This is a more complicated problem even than the Green Peafowl because there's no actual damages. Because the Green Peafowl case, you can see the habitat will be destroyed and they won't be able to stay as a species. But here, it's very hard to argue there are damages. So the claim is according to the Renewable Energy Law, Article 14, that require the state grid to guarantee full purchase of the renewable output, and they violated these rules. But as mentioned, they have to tie to the framework of environmental public interest litigation. They still have to frame what's the harm. So they work very closely, CSO work closely with the legal experts and also climate change science, damages appraisal experts to frame the curtailment as environmental harm, that if they use renewable energy, they won't be need to use coal-fired power generated electricity, and that emissions for carbon credit will be enormous. Guess what's the result? Again, there's many hurdles of the procedure. The case was not able to get into the court in many times, but finally they get into the trial court and they got a settlement. But it's not until the case was filed in 2016, and it was not until April 2023 the Gansu Mining Court issued the mediation agreements. And the mediation agreement basically affirmed the violation of the state grid of the renewable energy law and asked them to put more dollars. I don't know the exact dollar, but it's 960 million yuan on top of the 9.6 billion they already spent on upgrading the grid to absorb the renewable energy. So this case I haven't mentioned another, because they simultaneously sue the Gansu branch and the Ningxia branch. The Ningxia branch doesn't even support any claims. They rule they fail. But surprisingly, they actually support all the litigation fees of the NGOs. That's a very weird rulings because they recognize the efforts CSO put into for public interest. So they're willing even rule in you lose the case, but I'm supporting your litigation fee. But that case actually have policy ripples and systematic effects. They actually help the court act as a facilitator, because the state grid the reason why we cannot buy the renewable energy power, because we have to negotiate with the provincial government that they only give us this amount of renewable energy, and they have to protect their provincial-owned coal-fired power plant. So this is really showcase Professor Zhou's logic, how you can play a role between the central authorization and also the local effectiveness of the governance. Okay. It seems I paint a really good picture. Even in the tight control era, the two cases are very successful. Now I have to give you a more not happy pictures. I know this image is not very well, but this is actually not my paper. It's published by Dr. Xie Lei, and they found actually immediately after the EPL, the Environmental Protection Law, authorized the CSO to file civil public interest litigation. They realized there may be too much great rights to CSO. So in the end of 2014, the central party's decision is called promoting prosecutor-led public interest litigation. You might be here for Professor Dr. Jeremiah Dom's lectures. He mentioned the functionship of prosecutors, and now in order to take away the anti-corruption power, now they give another power, file public interest litigation to the prosecutor. And in July 2015, the National People's Congress initiated the pilots for the prosecutors. And immediately prosecutors have this role, their cases are skyrocket. You can see they are outgrow of any CSO file public interest litigation, thousands of cases. Right now, the CS only file maybe 3% of the public interest litigation, and the prosecutor-led CSO actually can both file against the polluters, ecological destructor, and also the government. In addition, on top of that, the central environmental inspection teams, the campaign style mobilization to do enforcement, and also the new reform on ecological environmental damages and compensation system. So that means the local EPBs, local environmental protection bureaus, they can themselves also negotiate environmental damages with the polluters and also file case with the courts. But even though they realized the CSO cannot be given so many rights, but they, in 2020, when the General Office of the CPC Central Committee and the State Council, they issued the guiding principles, guiding opinions on building on environmental governance system, they still recognize the NGO's role, or the CSO's role. So it is, they still think the the general public and the CSO has the role to play. And just 4 days ago, there are new pending legislation deliberate in the standing committee of MPC. The draft ecological environmental goal was under second review. And you can see the article here in the draft code. The CSO's legal standing still remains. So I'm so afraid that I've been taken out because they are. This, if adopted in next year, this will be the second sectoral law be named as a code. So ecological environmental code. The first one was civil code adopted in 2020. But we're so afraid that the three pillars of environmental rule of law access right be taken out, but they still remain. It's there. But on the other hand, there's a new legislation deliberate, and just in the first review, that's submitted by the Supreme People's Procuratorate. It's called Draft Law on Procurator Public Interest Litigation. And it doesn't specify to environment. It can be on national assets, food security, et cetera, et cetera. But you can find there is no public interest litigation law generally for every actors and only for prosecutors. So back to our question, can China's environmental CSO still make a difference? So as a observer and scholars and a participation interaction with this process for more than 2 decades, I'm cautious optimistic because, as I mentioned, during the loose coupling era, the legal standing, the access rights has recognized their roles. So like IPE, they can be a knowledge broker. Like Friends of Nature, they are fire alarm and file the litigation. And many small NGOs are now the collaborator. They actually work very closely with the prosecutors and the patrolling, and actually sometimes jointly file the case. And we're also experimenting the ecological restoration monitoring project. No matter the case is filed by prosecutors or CSO, you still have the court orders implementation phase. And ecological restoration are a long time process. You still need a team to monitor the feedback loops. So there's many arenas for innovation. So as also Professor Zhou mentions, the iron hand is not iron board. It moves. So the practice are not always characterized by a high concentration of power. Not all they always stable subcontrolling, or rather they reflect a process of variable coupling between the state and bureaucracy power. So as the saying goes, 留得青山在，不怕没柴烧. So if the Green Mountains remain, there will never be a shortage of firewoods. So the progress is not linear, but adaptive. So a balance of state control and civil collaboration. So to end my talk here is, I'm a cautious optimistic. So each CSO file cases, each data, each blue map release, every environmental impact assessment comment submitted by public and CSO build up the procedural memory and advances the rule of law step by step. I hope you also have this cautious optimistic. Thank you so much for your listening.
Thank you, Professor Lin, very much. I think Professor Lin's work, both as a scholar and as a consultant advisor, has been extremely important in promoting progress with regard to environmental protection in China. It's very impressive. I've learned a lot from it, not just this paper, but her years of work, and I stand in admiration of that. So the comments I have to offer are very much in that spirit, in the spirit of admiration for you. So first, I think the insights from her paper, both explicit and implicit, surely are right. By that, I want to make a couple of points. So first, though she's not said this straight out, I think her paper really pushes those of us here in the U.S. To move beyond our assumptions. That is, assumptions formed largely on the basis of the experience of the U.S. that a civil society organization or an NGO must act in a directly adversarial manner toward the state in order to make progress. That's something that almost naturally seems to come from our litigious rights-based society here in the US, but there's no reason to assume that that has to be the case everywhere. And indeed, as I'll comment on later, I'm not even sure it's always should be the case here in the US. So first of all, commend you for pushing us to go beyond our assumptions. Secondly, and this is explicit in the paper, as you just heard, Professor Lin very much helps us by laying out some of the many ways in which the party state has embraced environmentalism, ecological society, as an important national policy, including espousing this idea of ecological civilization in the Constitution and elsewhere, substantially revising many laws, the Environmental Protection Law, and many others. She mentioned the 3 excesses, which happily still are there: access to information, decision-making, and justice. The establishment of what now, according to the Supreme People's Court, is more than 2,500 different kinds of branches, tribunals, benches, other decision-making entities about environment. And I might add, in addition to the many dimensions that she mentioned, increasingly cadres are being evaluated according to whether they meet certain benchmarks about the environment. And as we all know, China has become the world leader with regard to the production of solar panels, electric vehicles, nuclear power, and much more that shows some serious commitment to clean energy. So these things are important in themselves. And third, as Professor Lin indicates, they send a signal to local officialdom, to courts, and to civil society organizations that it's permissible to raise issues about environment, indeed, even in some cases, in some instances, encouraged to take advantage of this sort of opening to bring environmental problems to the attention of officials and courts. And fourth, Professor Lin, again, both in her scholarship and her wise counsel, indicates how astute civil society organizations are working to adroitly use these openings. So the clap you mentioned from the 中国政法大学, Professor Wang Canfa came here 20 years ago.
Yeah, actually, he's my PhD supervisor.
Oh, really?
Yeah, I think I can engage in so many cases. Also,
yeah, he's great. He's a very impressive guy. And you see how very clever, smart people are figuring out where the cracks are, where the openings lie, and working to take advantage of it. The fact that somebody could go after State Grid, which is an extremely important company in China, shows you how creatively people can work. And the secretion, as Professor Lin has told us, builds up over time, even if gradually and sort of incrementally. So there's a lot to be grateful for. And again, both as regards environment and perhaps the lessons that might be extracted more generally. Having noted that, anytime a law professor is asked to do anything, they always have the but for. So having noted this, let me offer a few suggestions for possible inclusion by Professor Lin as she revises the paper. First, as I've just said, I think these steps to promote ecological society are for real and they're important. But I think it's also important to keep in mind that there are other state policies that are at least as prominent, including maintaining social stability, namely the role of the party, and fostering economic growth. And I think the real test of the depth of commitment to ecological society will come when we see the sort of outcome of times when these policies are in tension with each other. Policies, again, about state stability and about the economy. So even as China is trumpeting its commitment to ecological society, it's engaging still very substantially in activity pursuant to major policies that works in a very different direction. So just by way of example, China produces more cement now per year than the rest of the world combined. China produces more than half of the world's steel, even though its population is a little more than 20% of world population. Its global carbon emissions are the world's largest, although much less per capita than here in the US. And it's continuing still to build new coal-fired plants, albeit much more clean than old ones. And the Yarlung Sampo Dam in Tibet is the world's largest and is said by scientists at Yale to have been producing quite a few serious ecological harms. That's a dam that costs $167 billion. This is a big undertaking. So I mention all these things not in the least to discredit the steps that China's been taking to foster a better environment, but again to raise the questions of what will happen when different policy objectives interact. China, as we all know, is now dealing with a major unemployment problem, the exact extent of which we just don't know. I mean, it's not fully public, which is one reason why Chinese factories keep pumping out exports, even in the face of wildly fluctuating U.S. tariffs and clear unhappiness on the part of Europeans and others about being the place where diverted exports go. So it's hard to envision, in the short term at least, less demand for energy, particularly in the winter. We all know a few years ago there was a major energy crisis, and less industrial activity. And so I can't help but think that when environmental activism is likely to have a major impact, a meaningful impact on things like employment, that concerns about social stability are going to predominate. So that's my first sort of caveat. Second one, I think we see something similar with respect to the capacity of civil society organizations that I think could be good to note. As you yourself have indicated, and some of your other very fine scholarship, there are still several important areas that are off limits. So civil society organizations cannot seek judicial review of environmental impact statements, pollution permits, land use zoning, limits obviously in going after the government directly, all these quite important. In addition, my sense is that many environmental issues require a high degree of scientific or technological capacity on the part of an NGO, or for that matter, prosecutors or courts, but on the part of NGOs to identify and know how to seek redress for, whether it's seeking redress in courts or elsewhere. And the fact is that China's CSOs are generally not well funded and generally are locally focused rather than national or international in their scope. This, I really want to underscore, is not by accident, but really is a product of willful design by the party state in the interest of social stability. The 2017 NGO law basically cut off funding from foreign sources, which had been quite important for many CSOs. The 2014 Environmental Protection Law circumscribes the range of NGOs that can go to court for public interest litigation. There are 5,000, as Professor Lin, as she noted, and she correctly noted, also many of them are very small, but the number who are actually eligible to bring cases is yet smaller. And in general, policy and law work together in China to keep NGOs focused very much on their local area rather than forming national organizations, even though we all know that many environmental problems, particularly things like acid rain, transcend local borders. And also, as I'll note more in a minute, sometimes local forces can preclude local, serious, meaningful local CSOs from being able to act. All this is another way of saying that I'm inclined to see the progress made and makeable as owes itself to the parties seeing it advantageous to have CSOs doing things to promote certain party goals. But by the same token, it also means that the things CSOs can do are very much subject to shifts in the party's preferences, policy preferences. Again, especially when it comes to things like stability and economic growth. So my points so far have been largely about the national policy, but I also want to bore in a little bit on sort of on-the-ground remediation at the local level. Speaking in very gross generalities, I'm sure there are exceptions, my sense is 天高皇帝远, that whatever Beijing decides, whether it's progressive policy or regressive policy, implementation at the local level is going to have a lot of variety over a continental-sized country with 20% of the human race. I have no doubt that adventuresome CSOs, especially when they're aided by extraordinary people like Professor Lin, can take advantage, and we saw it with Wang Sanfa and Klopfe, they can take advantage of openings just as she's described, but there are several limitations that come from that as well that I want to note. In part, this is things that you've already noted in other writing, and our former, Professor Wu's former students, my former students, Xia Ying and Wang Yueduan, have noted some of this in their very fine work. And so, that, for example, the bureaucracy really is taking the lead in environmental public interest litigation that involves state-owned enterprises or so involves activities of government. And I think Xia Ying and Wang Yueduan have shown that, at least in the samples they've studied, bureaucracy tends to not ask for extreme remedies. It tends to be kind of careful and modest. So it leaves it to civil society organizations to bring cases against private companies or to suggest more radical kinds of remedies. So that is a limiting factor, again, especially given how small some of these CSOs are. And there are also certain kinds of things that only the bureaucracy can do, again, as you've remarked and noted elsewhere, such as filing administrative public interest litigation of certain types. Another sort of related challenge to all this at the local level is that, picture a CSO, small NGO, whatever, going up against an important local company that's, say, the major economic revenue producer in an area, or might in less attractive ways be connected to powerful authorities. So that's often a very hard thing to do. And as the work of Professor Rachel Stern at Berkeley suggests, this may be one reason that local lawyers are often reluctant to get involved with CSOs suing major local companies. And therefore, CSOs have to go to Beijing or Shanghai to try to convince some public-spirited mind, higher profile person to come out and help them, which sometimes they do and sometimes they don't. And it's probably a reason also that explains another finding of Professors Xia and Wang, that there now is a growing number of what she calls, Xia Ying calls guerrilla lawyers, and that is lawyers have just grown so disenchanted with the possibility of working for CSOs, of getting real relief, that they see their role really just as one of raising the flag, as you say, publicizing, even though they don't think there's much a remedy available. That brings me to another, I'm going to stop before long, but another comment about institutions. And here I have comments about both courts and about public inspection campaigns of the type you mentioned. So years ago, Professor Bill Kirby and Professor Ken Winston and I did a book about professionals in China. And I think it's fair to say that the educational level of the judiciary has improved very substantially over time, and that there's more professionalism in the judicial system than before, at least with regard to matters that are not relatively highly political. And yet, I think it's important to take account of the ongoing challenges that judges and professionals in the judiciary system face. First, they're just overburdened with the number of cases relative to personnel, particularly given reductions in the number of judges. Second, they may not have the expertise, technical and scientific expertise needed to solve cases. Third, enforcement, as you would probably know much better than me, in general, still remains a serious problem against, especially judgments against major important actors. So in kind of looking at victories in the courts, which is definitely important, you've traced yours all the way through, it's vital for us to remember that it's not just the decision, but the actual change in behavior. That's not limited to China, as we look at what's happening now. Our governments in some other countries, including this one, always following what courts say. And finally, just on the courts, the position of judges. So I still haven't figured out whether the addition of the idea of lifetime responsibility for judges is a factor leading them to be more scrupulous in making decisions according to law, or to be more careful about hewing very, very closely to what they think is the current political line. Finally, on inspection campaigns, yes, if they're carried out well and consistent, they could have impact that you suggest, but Professor Denise Van de Kamp of Oxford shown that earlier, to be sure, a decade ago, that there's an intermittent quality to them. This strikes me as very consistent with how I see human nature everywhere in the world. And that is, when you know the inspectors are coming, you clean up and you put on a good show. And then at the end of the week, when they go home, life goes back to what it always was, which is not necessarily following through on things that are difficult. So I think, again, important to flag it as you have, but also see its limits. So in closing, I want to underscore that in raising these points, my goal is not to take anything away from the very impressive work that Professor Lin has done, both academically and as a participant. I think history will remember her very well for having done this work. I think it's important to realize our assumptions in the US that CSOs need to be adversarial is just that, an assumption that may well not apply more broadly. I was struck as I was reading your paper that even in the US now, even in liberal democratic circles, think of the recent book by Ezra Klein of the New York Times called Abundance, that there's an argument there that we've taken people who believe in environmental protection have taken too adversarial a posture on those issues with ways that have redounded negatively. They've undercut a constituency for environmentalism. Anyway, I just want to thank you again for introducing us to the fire alarms and the iron hands that remain and educating us all. Thank you.
Thank you so much, Professor.
So I think it's time to open the floor to questions. This is a good opportunity to talk to somebody who really knows what is happening. Yeah, please. Jin. Yeah.
Hi, my name is Jin. I'm an associate of the research associate of Fairbanks Center.
Please speak a little more loudly.
Yeah, my name is Jin. I'm a research associate of Fairbanks Center. My question is twofold. One is, in those two cases, did you follow up with enforcement, even though the ruling was very good? How was the enforcement afterwards? Secondly, recently, one of the hot topics is rare earth, Chinese production and dominance in the market of international market of rare earth. And one issue with rare earth production is environmental cost, environmental damages. Did your work involve or encounter? Did you ever encounter the environmental consequences of enormous rare earth productions in China? Thank you.
Thank you so much for the questions. Yes, I think for these two cases, we actually follow up very closely for the enforcement. I think, as I mentioned, the first case, because the provincial government actually put the areas to the ecological red line, so now it's actually illegal to develop the hydropower. So even though the order only is just suspended, but another era, so the administrative policy make it almost impossible, because as I mentioned, the arguments from the government, from the developers say it is legal all the way, but now because it was now under the new policy, so it's not legal, so there is no, they just decided abandoned, so there will be no construction. I think recently, Mr. Xi Zhinong, the famous wildlife photographer, go back to the areas, and he still found the habitats and a trace of the Green Peafowl. So they are very happy, and because they said it's a rare habitat. For the second case, actually this case is very interesting because just 1 year after they filed the case and the publicity of the case, the National Energy Agencies already issued the policy, required the state grid to develop more smart grid system to absorb the renewable energy, and the new next energy law require the state grid to purchase powers, so have more favorable incentives to the grid to purchase all the renewable energy power. So it's a rare dynamic. For the rare earth production damages, my personally hasn't involved of any of those cases. I know there is a few CSO monitor the sites and walk around, but they haven't found. As of I know, I haven't noticed any case environmental public litigation against the pollutions on this front. But they do the NGO, as Professor Alfred mentioned, a lot of them, actually majority of them, working local areas, and water pollutions, waste pollution is their main focus. So the EPO is a dramatic tools, but oftentimes, mostly they will start with file complaints. Just call up the local authority, tell them the pollutions. So since I haven't heavily involved in this area, so I don't know how to say, but yes, because now the rare earth mining and mining issues is always very difficult. I remember there are. Actually, the very first EPO is actually filed in 2011. It's in the test area. It's also related to mining. The plaintiff get into very difficult negotiation with the project developer because the pollution actually cause public health issue that will cause tort actions and stability of the village and the surrounding community is a more complex, and that those cases need much more patience and wisdom. Yeah.
Dinda.
Thank you so much for this fascinating talk. I'm Dinda Elliott at the Fairbanks Center for Chinese Studies, and I'm wondering, forgive me, this is a little bit off the topic of environmental law per se, but given, you've both talked about the Chinese government's commitment to the development of an ecological society and all this kind of stuff, what types of environmental organizations are feeling the greatest constraints these days? I mean, given that the government has said, yes, we do care about this stuff, and yet, my understanding is that environmental NGOs and CSOs are feeling some pressures. So, what are the tension points?
So, I think the constraint come from all sides. Professor Alfred already mentioned the 2017 law. I think the key constraint on the funding side. Because actually the survey disclosed the one of the key reasons of the small staff of the CSO is really low support for the CSOs because it is outside the party-state system and they don't have good career path. And this is one, and the second, they still have they have to still report to the supervision unit, the civil society management laws, the charity laws. There are many. This is another route, another field of the legal system, but that hasn't been relaxed as we hope during the loose coupling era. That we hope there will be only registration organization, but the dual system still remain. So so there are some sensitive case. I have one student ask how they stop the CSO. I said they don't need to hire a very expensive attorney to fight against you in the court. They can just walk around and then ask your supervision unit something to just withdraw your license. Yeah. So.
But I wanted to ask, why would they want to withdraw the licenses? Is it the NGOs that are pushing for a particular kind of environmental thing, or it's NGOs that are going against specific, economic or business projects, or what,
Yes, I think in case of environmental public interest litigation, yes. So if they particular file against, so as I mentioned, the Peafowl case now is named as a landmark case, but in the beginning, we are very pessimistic because you're suing a big hydropower dam. They're backed by very strong power. There's another case actually backed by a much stronger power. So that case it's trigger that constraint.
that case is more difficult?
Yeah, we don't. Yeah.
So I agree very much with Professor Lin's observations. Just to add a few more things very much in the same vein. So foreign funding is really it's not there anymore, right? And that was a big and important thing. And I think some of the foreign substantive contacts also have diminished. Happily, Professor Lin's still involved, but I think, and happily, Professor McElroy is not so much with CSOs, it's more with serious scientists, but I think in general there's just much less foreign assistance. And domestic charity law, I think my sense, I haven't studied it, is that major benefactors in China are not going to give to anything that's too threatening to the state, right? They're going to give to things that are, there already are specified purposes in the charity law. And then it's a question of tactics also, Dinda. So sure, litigation is one thing, but in many other countries, CSOs would call for people to go out in the streets and demonstrate. So that probably wouldn't be too well advised if you were a CSO in China today. Then I also think, and maybe Professor Lin, correct me if this is old, but back when we studied, myself and Ben Liebman 20 years ago, the really interesting drafting of the air pollution law then, where most outsiders were just saying they couldn't draft a sophisticated law, was that the pro-environmental people drafted a very sophisticated law, but then the coal interests and people from Gansu and Sichuan governments weren't so keen to have that law. And so it's a sectoral battle. And I suspect there are similar things today. So if you're bringing a case against, that's why the state grid case is really, really fascinating. If you're bringing a case against, even if you have support of environmental officials, they're not going to be as consequential as several other kinds of ministry officials. So the pressures, there might also be a factor. Professor Greenhall has an answer, a question too.
Oh, hi. My name's Nicole. I'm a law student here. And I was wondering, so you mentioned that the meeting in Kunming kind of contributed to the decision in the Peafowl case. And I was wondering if you think that sort of a desire on China's part to become a bigger leader on the international stage, particularly with regards to environmentalism, could lead to changes or more support for environmentally minded decisions within China?
Thank you for this question. That's first, I never been into the really inner circle of the leadership, so I don't know exactly what they think, but that's how it shows chronically, because the trial was held in 2018. But we way many campaigns and public education, raise awareness. But it's not until March 2020 they hand down a very favorable decision, and that actually during that same time they changed the venue for hosting the COP from Beijing to Kunming. So I think at that moment everybody in the group said we may be able to get a good chance to win this case. So I think this also the insight from Professor Xue Guangzhou's framework. One of his aspects is the rhythm of opening up and shutting down. If we're more opening up to the world, and in particular environmental protection, the planet needs China's collaboration with other parts of the world, and civil participation, as I mentioned, ensuring in the Principle 10 of the Real Declaration. And if we are the signature party of the convention, and China will be the leader in the global environmental governance, and will support the public participation, and we hope that will create more space for the CSOs.
Can I add a quick comment? So I've been trying to figure out, I don't know the answer, the U.S. retreat from the Paris Agreement and the whole idea of climate change, clearly it creates an opening for China, and already rhetorically, at least, the Chinese leadership has indicated that it supports keeping global focus on climate change. But whether that will spur China domestically to take more action to advance things, or whether the absence of a need to, at some point, keep up with the Americans or have a deal with the Americans on climate change will mean there isn't a lot of pressure domestically from this international mirror, I don't know. I think only time will tell us. But I do think China has actually quite an opportunity now. Sadly, that the U.S. has retreated on that front.
I do want to mention there are some, I think one of the key allies for the grassroots CSO is the government-affiliated NGO, so we call gangos. So they work as a networking organization. So right now they actually still forward a team of CSO to participate in the COP30 in Brazil. This is amazing work. They lead the grassroots CSO to participate in the global stage and have conversation with other peer CSO from other countries.
And I think Professor Greenhall, we have time for one last question, so.
Thank you both of you, for a really, really interesting discussion. So in his comments, Professor Alford brought up a series of, is it on? Can you hear? Yeah, sorry. In his comments, Professor Alford brought up a series of constraints on the kinds of legal activism that you're interested in and we're all interested in. And one of them was the CCP's unending commitment to economic growth at any cost. And I've seen that in my own research too. I don't work on environment, but related research. So my question is, have you, in the contest between environmental goals and economic goals, have you seen any trend at all in favor of the environment, or even a trend in the other direction, or is it just hard to say?
Thank you both to mention the targets. I think it's not until the 11 5-year plan that the China incorporate the environmental targets to the evaluation of the cadre. And I think that's very important targets. Although it's, as you mentioned, it's because the right now is economic downturn, whether the cadre realize we can be just not growth. And 金山银山绿水青山就是金山银山. So Green Mountain and clear water, it is grow. So it doesn't matter you have the economic growth. I feel like it's not just about the attainment of economic growth, but also seriously related to what Professor Alford said, the stability and the party control. So the legitimacy of the after the open and reform era, the party state's legitimacy built on economic growth, and now seeing the 两山论, seeing the ecological protection is one of the legitimacy, but also stability. So it's so hard. I think I kind of it's very hard to. But I think there's some maybe there's some changes on understanding of human flourishing. So I really admire Harvard School have a human flourishing program. I think this is the challenge for the world, is to have another imagination of the mankind, how we should live a happy life, in addition to just materials growth and competition.
What a great note to end our conversation on, a more than material goods. Thank you so much, Professor Lin, for excellent talk.